So, in this video, we'll discuss what is mortgage, why deposit of title deeds, mention its characteristics, why it is called equitable mortgage. So, the very answer we found under section 58 clause F of Transfer of Property Act 1882. A mortgage by deposit of title deed is a form of mortgage recognized by section 58A F of Transfer of Property Act 1882, which provides that it may be effected in certain towns where a person delivers to a creditor or his agent the documents of title to immovable property with intent to create a security thereon. Under the definition of a mortgage by deposit of title deeds as provided under section 58 subsection F of the Transfer of Property Act, the essential requisites are: one is debit, the second one is deposit of title deeds, and the third one an intention that the deed shall be a security for debt. So, in that connection, we would like to discuss one important leading case, and that is K.J. Nathan versus S.B. Murthy Rao in 1965. Supreme Court expressed that physical delivery of documents by the debtor to the creditor is not the only mode of deposit. There may be a constructive deposit. A court will have to ascertain in each case whether in substance there is a delivery of title deeds by the debtor to the creditor. If the creditor was already in possession of the title deeds, it would be hyper-technical to insist upon the formality of the creditor delivering the title deeds to the debtor and the debtor redelivering them to the creditor. What would be necessary in those circumstances is whether the parties agreed to treat the documents in the possession of the creditor of his agent as delivery to him for the purpose of transaction. So also when the principal tells the agent, from today you hold my title deeds as security, there is in substance a physical delivery. For convenience of reference, such a delivery can be described as constructive delivery of title deeds. The law recognized such a constructive delivery. So the question whether on the facts found a transaction is a mortgage by deposit of title deeds is a mixed question of fact and law, as it was declared by the Supreme Court in this particular leading case, K.J. Nathan versus S.B. Murthy Rao in 1965. So now we'll go to the first essential requisites, that is debt. As in other mortgages, the debt in a mortgage by deposit of title deeds may be an existing or a future one. It may also be by way of present or future advances. The title deeds may be deposited also to cover a general balance that may be found due and running account. And the second essential requisite is deposit of title deeds. And regarding that, the second element is that the debtor should deliver documents of title to immovable property on which the security is intended to be created to the creditor or his agent. It is, however, not necessary that the property to which they relate should be situated within one of the towns mentioned in the clause. It is enough if he hands over the title deeds to the creditor in that town. So, in that connection, we would like to discuss another important leading case, that is Central Bank of India versus Nusrat Jani, and decided by Bombay High Court, where it was held that the property may be situated outside the town mentioned in the clause. For example, mortgage of property in Mirzapur may be made by deposit of title deeds in Allahabad, as it was decided by the Bombay High Court in this leading case, Central Bank of India versus Nusrat Jani. And now we'll go to analyze another decision, that is also the same decision that already we have discussed. K.J. Nathan versus S.B. Murthy Rao in 1965. Supreme Court observed it would be hyper-technical to insist upon formality of the creditor delivering the title deeds to the debtor and the debtor re-delivering them to the creditor. In this case, the title deeds were already with the lender or the creditor, whereon the directions of the debtor, the creditor, after his debt is discharged, sends the title deeds to another creditor. This is a case of constructive delivery. Again, what is to be deposited must be document of title. If the documents deposited show no kind of title in the depositor, no mortgage is created, as it was decided by the Madras High Court in Lakshmi Vilas Bank Limited versus Sri Chakra Enterprises and others in 2003, as the very deposit must be document of title, as it was held if the documents deposited show no kind of title in the depositor, then no mortgage is created, as it was decided by the Madras High Court in 2003 in the leading case Lakshmi Bilas Bank Limited versus Sri Chakra Enterprises and others. And now we'll discuss the ruling of another important leading case, that is Messrs. Raid Master Rims Private Limited versus ING Vaishya Bank 2007, also decided by Madras High Court, where it was observed that where Xerox copies of the sale deed along with the receipt of sub-register for having registered, the same was deposited with the mortgagee. It was held by the Madras High Court that the certificate of registration before the sub-register office is a proof of registration of a document, and therefore it becomes a document of title. And now we'll go to the last essential requisite, and that is intention to create security, and in that connection would discuss some important leading cases. So the third and the very important element is that the deposit of the title deeds must be made with a distinct intention of creating a security for the debt. The title deed shall be the security of debts and is the most important element of the transaction. And as in this regard, the leading case Jeta Bhima versus Haji Abdul, the Bombay High Court held that if it is in the contemplation of the parties to have a legal mortgage prepared, and if the title deeds are deposited for that purpose only, the deposit does not create a mortgage. The mere fact that the title deeds have been deposited is not sufficient unless there is an agreement that the deeds should stand as security. So, also we will discuss some other important rulings made by one is Supreme Court in that previous case that we have discussed, K. Janathan versus S.B. Murthy Rao in 1965, as Supreme Court observed the decision of the English courts making a distinction between the debt as regarding preceding the deposit and following the deposit can at best be only a guide, but the said distinction itself cannot be considered to be a rule of law for application under all circumstances, as it was observed in this important leading case Nathan versus S.B. Murthy Rao in 1965 by the Supreme Court. So also in another important leading case, Supreme Court observed that, and the very leading case is Bhirama Chenu Gangadhar Rao versus Andhra Bank Limited in 1971. Supreme Court observed that where the deposit of title deeds with the bank was to create an equitable mortgage for the loan applied for by the appellant, and the oral and documentary evidence unmistakably proved that the title deeds are security for the loans obtained by the appellant and could be treated as the contract for the mortgage. It is inadmissible in evidence as the same is not registered as required under section 17 of the Registration Act, as it was ruled by the Supreme Court in this important leading case, that is Virama Chennu Gangadhar Rao versus Andhra Bank Limited in 1971. And now we'll discuss another important leading case, and that is relating to the intention to create security, and in that connection we would like to discuss the very important leading case relating to equitable mortgage and why mortgage by deposit of title deeds is itself called as mortgage by deposit of title deeds is called otherwise equitable mortgage, and in that connection we'll examine and review the very decision of the Privy Council in the leading case Bhadu Seth Som versus Lakpati in 1862, where it was pronounced that in England mortgage of this kind is called an equitable mortgage as opposed to a legal mortgage, because in this type of mortgage there is simply a deposit of document of title without writing or without any other formalities. The object of the legislature in providing for this kind of mortgage is to give facility to the mercantile community in cases where it may be necessary to raise money all of a sudden before an opportunity can be afforded of preparing the mortgage deed. This mortgage therefore does not require any writing, and being an oral transaction is not affected by the law of registration. And in case in India, equitable mortgages have been recognized in this decision of the Privy Council in this leading case, Bhadu Seth Som versus Lakpati in 1862, where the term of equitable mortgage being inappropriate in India on account of the absence of classification or division of estates or rights into legal and equitable, it is called a mortgage by deposit of title deeds. So, the very mortgage by deposit of title deeds is a form of mortgage recognized under section 58 subsection A of the Transfer of Property Act 1882. So, the very question relating to mortgage by deposit of title deeds and its main characteristics and why it is called equitable mortgage, all that we have discussed as regarding the very provision that we found under section 58 subsection F of the Transfer of Property Act 1882, and this should be the correct and appropriate answer and the relevant answer to this question. And you know what? Next upcoming video will discuss question number 32, which asks explain the doctrine of clause on redemption and state the basis of the doctrine.